for you, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And we are live on Who Wrote That Up For You. Today is Wednesday, November 9th, 2022. I'm Sonia Ebron, co-founder at Courtroom 5.
And I'm Deborah Sloan, the other co-founder at Courtroom 5.
We've got a marvelous show lined up for you today. In a few moments, we will speak with Miguel Willis. Miguel was our guest back in late September, and we wanted to have a deeper dive with him, a little bit more of a conversation. Miguel is the Innovator in Residence for the Future of the Profession initiative at the Penn Carey Law School. And so we're going to talk with him about the future of the profession and the relationship to access to justice generally. Before we get there, though, Deborah, what's on your mind today? What is our issue of the day?
I want to talk about the, and I guess this is the peculiar law thing. It's it's the process or the uh, job of judges to liberally construe pro se litigant pleadings. And when I say liberally construe, I mean give a little bit of leniency to how a pro se litigant writes a pleading. And looking at Vermont Law Review, and they're talking about this, but the problem that they're seeing with it is that it's not fair to lawyers when there's a pro se litigant who is sophisticated. So the law actually, or the standard actually sees pro se litigants as all the same. And so they basically don't take into account a sophisticated pro se litigant who might actually know what they're doing. They still basically liberally construe their pleadings. And some judges even go so far as to liberally construe their motions. And so the article kind of supports the idea of not having pro se litigants be like a monolith, everybody's the same, deciding to liberally construe a pleading or a motion based on who the pro se litigant is, and what their abilities are. But my thinking is that a pro se litigant just has one case, and oftentimes they've seen a lot of this for the first time, even though a sophisticated pro se litigant may know civil procedure. This may be the first case they've had on, let's say, foreclosure, or the first case they've had on debt collection. So I support basically liberally construing it because they're not in court every day on this thing. And but the article says, well, it's just not fair to lawyers to have that happen. So it's just a
That,
difference of opinion.
that's a really fascinating subject. I didn't know that debate was going on. I didn't know there were lawyers pushing back on that doctrine. I think I understand it though. I think you are the one they're pushing back against, right? People like you, who are able to do your legal research, who are able to argue, to present a legal argument to a judge, who understand civil procedure more than the types of pro se litigants that this rule was designed for, right? And so when you have a lawyer who is opposed by a pro se litigant, and the judge is providing them some leeway, some extra credit, if you will, and they're dealing with somebody like a Deborah Sloan, or I'm thinking about that example you gave a few days ago, the fellow in federal court who had set up a trap for robocallers, right? He had dozens of cases, I think, right? He was very experienced. And, when you've got a lawyer dealing with somebody like that, there's, there's not really room for leeway. For the judge to treat them to liberally construe their pleadings, because they'll just take something like that, extra credit like that, and just run the whole courtroom, right? And so I understand. I understand the concern. I'm glad that judges do liberally, or at least have a rule to liberally construe pleadings. I haven't seen it in my experience, frankly. I'll just say that, I'll just leave it there. So I'd like to see stronger attention to that rule, certainly. But I understand the concern of some litigators who are dealing with folks like you, or some of our members at Courtroom 5, for instance. I understand that concern. They're not. It's not altogether fair. For
Yeah. Remember, we had one a member get accused of that, that they
That's right.
that they should
They
not
must have
get
been.
pro se leniency.
That's right. That's right. Exactly. In fact, he wrote us a testimonial about that. Yeah, that he had lawyers complaining that he was that sophisticated. So that's great. And of course, our goal. I'll just brag about Courtroom 5. Our goal is that we don't need a rule like this. That every American is able to capably represent themselves and don't need a liberal construction of their pleadings or motions, for that matter. But we're a ways away from that, and so we do need that leniency from judges. I just like to see a little bit more of it. But I understand the pushback from lawyers. No, I hope they don't get their way on it nonetheless. That's great. Well, Who Wrote That Up for You is sponsored by Courtroom 5. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them, and we, the people, are coming to claim our courts. So if you are in court without a lawyer, or you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. At this time, it is my great pleasure to welcome back to the show Miguel Willis. Miguel, thank you for joining us on Who Wrote That Up for You.
Oh, the pleasure's all mine. It's great to be back, and it's great to really, yeah, be have use this as a platform. You all are doing amazing work. Talk about Courtroom 5 all the time, and the guests that you all bring on are phenomenal. And so, yeah, happy.
Thank you so much for that. Miguel, I introduced you as the innovator in residence for the Future of the Profession initiative at Penn Carey Law. Give us your background. Tell us how you came to that position.
Yeah, how I came there, interesting. I had started the fellowship, the Access to Justice Tech Fellows program when I was a law student in my second year of law school. That from bootstrapping my way up, I found myself in Alaska working on a project with the Alaska Courts as a fellow in my own program. Funny enough, the first for the pilot year, through the success of the pilot and the fellows and our dynamic legal partners, able to scale the program, now in its seventh year, in the 36 states with over 142 fellows. um, that work took me to LSAC, where I was able to grow and house the program, and then ultimately wanting to find a law school home. Penn Carey Law and the Future Profession Initiative was just launching, and I thought this would be the perfect house for the program to continue.
Extraordinary. Congratulations on the seventh cohort in your program. That is really tremendous work. And just so folks understand what you do at the Access to Justice Tech Fellows program is you take law students and you place them with folks working in access to justice,
Hmm.
whether it is tech companies or legal aid programs or wherever they can learn about access to justice issues while they are still in school.
Yeah, it's pretty interesting because some of the students that come in the program have tech backgrounds, some don't. We encourage everyone, especially diverse communities in law school, and underrepresented communities, uh, because they really shape and inform perspective at some of these projects. And so it's just been quite fascinating to see some of the fellows that come out the program and continue to come out the program. And yeah, I couldn't be in a better situation or platform and institution than Penn, who is really taking a lead on these issues and conversations. And yeah, just generally wanting to expand the work with more people, and support. I think we play a central role in supporting the instrumental work that so many legal organizations are already doing, and trying to identify ways to amplify that work through technology to support those that don't have a lawyer, those that organizations that maybe 2 to 3 people startups, or nonprofits that just generally didn't utilize technology or innovation and approach to provide legal services.
I just love the program, and I know some of your fellows, the graduates, and just what you're producing for the future of the profession. Just really excited about what you're doing. Let me ask then, what do you see as the future of the profession? What is the future of law, in your opinion?
Oh, that's a great question, and I mean, this is the future of the profession right here. I think it is diverse. It is people from people that really aren't lawyers. When I say the future of the profession, I'm saying how can we address some of these problems and challenges that are very pervasive in the legal profession. One is the health, right, and well-being. I've struggled with all types of mental health challenges through law school, and even out of law school. And how do we make a healthier profession where lawyers can
Mm,
thrive? I think is a question. How can we improve equity, diversity, and inclusion within the profession? And I mean that meaningfully, not just platitudes, but really, how can we empower uh, folks? Because not I grew up poor, but people that grew up in poverty, I hear this kind of terminology of lived experience experts, and sometimes I'm in these rooms and I'm like, well, hey, I know the answer. you know, it
mhm,
doesn't have to be this kind of your conceived notion of this person that's struggling poor that you want to bring in for to ask a question or interview and give a gift card. It could be somebody that came out of poverty and that is standing right next to you, that has the answer. But you really have to ask the question. So it's a lot. How can we really empower and change some of these long-standing norms that are just pervasive, that really cause harm on poor communities and working communities. Yeah, those are things that's where I want to see the future profession. But again, you're challenging powerful systems, so you know, it's a work in progress. So all we can do is, something that Cornel West said, you fail again, and you fail faster, and that's what we have to do to kind of continuously get the nuts and bolts uh, and pieces of change, right?
Yep, that's right. It is a very heavy lift, as you say. Some very entrenched powers and structures there that have to be uprooted. Um, and I'm thinking about when you talk about the future of the profession. By way of contrast, we don't have a future of bowling alleys initiative. We don't have, right, a future of, I don't know, photography initiative. Okay. What is it about the legal profession that requires us to dream a new future?
Um, because I think you hit it on the head. Like bowling alleys work for everyone, right? Libraries work for everyone. I think you don't have to be, whether you're Jeff Bezos or you're experiencing houselessness, you're going to get treated the same way when you walk in a library, and you're going to have access to the same resources and materials. Well, that's not the same, or that's not true for the law. And I think because of that, and because it's etched in the Constitution that equal justice for all, and this is, as a nation, as a democracy, that puts a lot of, you know, in the rule of law, we should upheld those values through not just talk, but how people interact with the justice system.
That is such an important point. That is such an important point that the present of law denies equal access, essentially, and so important to envision a future that includes or that provides that access. As you say, it's a constitutional right. I love that. And then, so let's talk then briefly about the lack of access. What does that look
Hmm.
like these days? And how can lawyers,
Hmm.
given the economics, I mean, the reality is most folks can't afford a lawyer, right? How do we restructure the legal profession, if you will? And I know this is
Hmm.
ongoing work, and this is going to be, as I said, a heavy
Oh.
lift. But just what are some of the ideas or leanings towards providing more access by re-envisioning the future of law?
Well, what the problem looks like, I think, is it's challenging and it's nuanced. One, it's not all legal, right? I think I don't like the kind of some of these are just policy and structural issues, failures of the executive, failures of legislators to build policy, which is dumping people into courts, and courts having to deal with a lot of problems. Um, and the whole notion that we can quantify everything into a legal problem. If I need, if I need food, I need food. If I need house, these are human rights issues, right? Not necessarily just a problem of the law. And I think to the extent that lawyers think they have a monopoly over justice, not necessarily true. Justice, I think, resides in communities, and communities are very resilient. And so, what materially that looks like, if I get denied, if I'm a mother or a father, and I get denied food stamps, a pill. I can't. It's harder to provide food on the table, or if I get that eviction notice and I have to move into a homeless shelter. It creates a challenge to keep my job. If my brother uh, uh, was, my father's a U.S. citizen, but my brother was not. My father naturalized, and he my brother got deported. So not having access to uh, a lawyer in a situation like that meant a serious consequences. And immigration law is a huge issue, but we kind of rub over just the real life human consequences of some of these issues, and especially for the families that are affected. So a lot of these things have huge dire consequences, and it's largely hidden from many who don't have a proximate connection to poverty, to those living in poverty or experiencing poverty. But I think one of the beautiful things is that, like, there's so much people that escape the grips of poverty. So I really think the future of the profession is how can we, and the future of law and justice, how can we empower those to help those? I think a community that's resilient. A lot of times when I hear stories from like my elders, like of how things used to be in like the 50s. Well, there's one adage of like, hey, there's this segregation thing, but there's another adage of, well, there used to be this community, right? And there you have these conversations where people can talk and support one another. Well, I mean, even in your I would say communities all over the place, like very resilient. When we were younger, we didn't have cable. We still got cable, So this whole adage of, uh, you have to have people are going to find a way to find a way, and that's just the kind of resilienceness of what someone has to do to provide. But is do we want to subject people to those? And that's that becomes the real problem because um, I always think when someone is responding to a legal problem, just their ability to respond. If you get hit with a judgment, and you're well off, you can easily call your lawyer, and that lawyer will step in and intervene. Not everyone has that access, and it's almost you have to sometimes remove yourself from the situation to say, hey, well, maybe I don't know the solution. Maybe not. I'm not the best person to answer this question. So it's sometimes sorry for on and on, but
You are beyond perfect, I must say. The lens that you bring to this issue, the human rights perspective, the rule of law perspective, the community resilience as a mitigating factor here, I think is so important to any real solutions to any vision we might have about the future of law. So I just so appreciate the work you're doing there. Big ups to Penn Carey Law for recognizing your brilliance and bringing you on as an innovator. Miguel, I'm going to share the law school website there. Where else can people find you on law?
yeah,
Online.
you can find me on LinkedIn. You can find me on Twitter, and I'm doing engagements like this. I do want to give a shout out to our team. One of the things that I really love about my work is we're working with just a phenomenal team. Uh, Jim Sandman, former LSC president, came to Penn with just a fantastic and a Penn alum as well. Jennifer Leonard, who leads the team, and we just had Chief Justice Bridget McCormick, who joined the team.
Mm.
And so, really, a launch of a new kind of legal innovation lab to support and nurture, early stage projects. So there's I'm very optimistic, and I'm most optimistic in the students and the youth. Right, I think the youth ultimately have. I love this new Gen Z generation that just they take no nonsense,
Yeah.
and they hold people accountable in ways that I couldn't even think of, and their use of technology is really surprising and amazing sometimes. So while there's a lot of things to be discouraged about, I think there's ultimately more things to be very optimistic about. And I think through our collective, we're going to be able to address this problem seriously. Um,
Yeah, we are in good shape when I look at this latest
Mhm.
generation. You're absolutely right. We don't have a whole lot to worry about there. Miguel Willis, innovator in residence for the Future of the Profession Initiative at Penn Carey Law, and executive director of the Access to Justice Tech Fellows Program. Thank you so much for joining us and
oh,
sharing your
thank you very
story.
much for the
We'll-
platform.
We will have you on again very soon. Thanks
All
I
again.
right.
appreciate it, Deborah. Appreciate it, Sonia.
That's great.
Fantastic, just fantastic. Well, Deborah, who won yesterday's quiz, and what do you have lined up for us today?
We did have a winner, and although I thought it was kind of a hard question, but we had a good winner. Which of the following are important at the complaint stage of litigation? A, evidence, venue, and liability. B, witnesses, prayer for relief and discovery. C, service of process, venue, and jurisdiction. And D, depositions, venue, and jurisdiction. And the answer, of course, is C, service of process, venue, and jurisdiction, because at the complaint stage, everything is about the complaint, how it was written, how it was delivered or given to the defendant, and so on. And so the winner is CCM.
Congratulations to Cece there.
And so today's quiz then. In the lawsuit Kelsey filed against Dr. Fig Newton for medical malpractice, Dr. Newton files a motion for judgment as a matter of law, a JMOL, people call it. What must Dr. Fig Newton prove to win? What must he prove to win on that particular motion? If you want to participate in today's quiz, send your responses to quiz@courtroom5.com.
I am looking forward to the responses to that one. I must confess, I don't know the answer, so I'm sure to learn something on that one. Fantastic. I just wanted to reflect on Miguel's comments there. I am so inspired that first of all that we're able to have conversations with brilliant minds like that, and secondly that there are folks working at that level on some of these issues, connecting what lawyers are going to be like in the legal profession in the future to the core problem, I think, in our society, which is the access to justice and the crisis that we're having there. It's just so important that we're able to see this level of work. We're going to solve this problem with folks like Miguel in the game.
Yeah, I was relieved that there was no Star Trek and Star Wars stuff. That when you ask somebody about the future, you see a dark. Okay, this is
Yeah,
somebody's going to be beaming up in a minute. But I like that he focused on equity and access to justice and how you treat people, and I think that is the future of law.
that's just the
So
future of everything. That's
yeah,
exactly
yeah,
right, as
yeah.
well as the diversity part of that. So important. So fantastic. Well, that's all we have for you today. As always, thanks for joining in, and we will see you tomorrow. Thanks, everybody.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.